key difference is peace bond is what you probably want. Again, I'm a criminal defense lawyer, so I'm looking at it from the accused standpoint. A peace bond is no record. You do not admit guilt. You essentially agree to keep the peace. You acknowledge that there was some fear on the complainant at some point based on your actions, but again, you do not admit guilt. And then the judge will place you on conditions for a period of usually 12 months. And as long as you do those, you get no criminal record and there's no admission of guilt. A conditional discharge, again, is no criminal record. However, in that case, you do have to admit guilt. And then it's the judge that's essentially choosing not to give you a criminal record or putting a record on your blemish on your record. However, you want to be careful because when you admit guilt, there's also other implications. You could get sued civilly, for example. So even if you got a discharge, the judge doesn't put it on your criminal record, but then you admitted essentially that you may have assaulted someone, if that was the charge, and then that person can sue you in civil court because you've already admitted something. So you want to be careful. And then a suspended sentence is the same thing. You have to be found guilty or plead guilty to get a suspended sentence. It might have the same terms as a peace bond or a conditional discharge, but it's that one step up from conditional discharge to suspended sentence / probation, which makes it a criminal record. So that's the key differences. One, suspended sentence is a criminal record. Conditional discharge not necessarily a criminal record, but does have some negative consequences, including pleading guilty. And then peace bond is what you generally want, which doesn't really have much consequences other than abiding by conditions for a period of 12 months.